Assalamualaikum and hi, I'm Hidayah and my partner AZMA will be discuss a legal case. So the first case is about Prince Jefri Bolkiah versus KPMG in 1999. So for the intro of this case, the Prince Jefri Bolkiah versus KPMG case in 1999 produced a landmark ruling on client confidentiality. The House of Lords' decision in the Bolkiah case highlighted the responsibilities of UK members acting for clients with conflicting interests. Facts of this case: claimant is Prince Jefri, the son of the Sultan of Brunei. One of claimant's firms hired KPMG to conduct a litigation investigation. The inquiry included tasks often undertaken by solicitors. By May 1998, KPMG had stopped working for the claimant. So the KPMG was then asked to help in an inquiry that favored the claimant. KPMG agreed not to use or disclose any of the claimant's information. So the court ruled that a fiduciary may not operate for and against the same client. Solicitors and auditors were in a very separate roles, even if auditors act for both sides. A solicitor in possession of confidential or privileged information should not behave in a way that puts such knowledge in the hands of someone else. Unless there is no risk of disclosure, the court should interfere. So next we see the liability of auditor. Duty owed in these cases is related to the confidentiality between old clients and new clients. The retainer ends the solicitor-client relationship of trust. That is also the end of the auditor's duty to protect or defend his former client's interests. And then the only obligation an auditor has to a former client once the relationship has ended is to maintain the information disclosed during that period. So next I pass to AZMA.
So now for the Auditor Defense, KPMG agreed not to utilize or reveal any information concerning Prince Jefri affairs obtained through Project Lucy. KPMG argued that this was the only remedy available to Prince Jefri. BIA admitted that it had no right to ask KPMG to use confidential information belonging to Prince Jefri. It objected to an injunction preventing KPMG from working on Project Gemma, citing undue disruption to Brunei's investigation. KPMG stated that a substitute could not be located easily since just a few firms have the appropriate capabilities and resources to conduct a large-scale inquiry. The BIA noted that it does not want more people or organizations to have access to its confidential information. It feared an injunction would prevent KPMG from auditing the key funds for 1997. The principle or concepts highlight from the case: the responsibilities of members in circumstances where the interests of two clients or of a client and a former client conflict and where the member is holding confidential information about one which could be used to the benefit of the others. For the conclusion, the right of confidentiality is not confined, like privilege, to particular categories of information but applies to all information in which confidentiality can subsist and usually depends upon the information having been communicated in confidence. A document may, for example, be subject to an exemption from having to be disclosed in litigation because it was brought into existence for the purpose of obtaining legal advice, even though it contains no confidential information.
Hi and Assalamualaikum. My name is Sofia binti HASHIM and in today's video I'll be talking about Caparo vs Dickman. So these cases was used in determining duty of care using 3 stages, and the fact of this case goes when Caparo wanted to acquire Fidelity using the financial statement prepared by Dickman. But when Caparo acquired Fidelity, it is seen that the value of company is different from what had been stated by Dickman. So the liability of the auditor is Dickman does not owe any duty of care to Caparo, as from this case it is set out that an entity only owe duty of care when there is a reasonable foreseeing of harm, sufficient proximity and fair and just and reasonable to impose a duty.
Hello, welcome to news. I am Aina SUKRI. Auditor Defense. The purpose of publishing account, according to Binhan LJ, was to inform investors so they could make decisions about how to use their share within a company. Principle or concept highlighted from the cases. The first 3-stage test is foreseeability. The harm must be reasonably foreseeable as a result of defending conduct. Proximity is the second principle. The inquiry focuses on the parties' closeness and directness. Possibility must be considered. The more obvious the accountant act or omissions will harm the shareholder, the less likely a court will hold that the accountant shareholder relationship is insufficiently proximate to give a rise to a duty of care. The third requirement is that the court must find it is just and reasonable to impose such a duty. The investigations consider the party relationship, the risk, and the public interest in the proposed solutions. Imposing liability must be fair, just, and reasonable. Conclusion: following the Court of Appeal decisions, the House of Lords held that the existing or potential shareholder has no duty of care. In fact, the accountant was unaware of the Caparo existence of the purpose of the account due to the insufficient proximity between them, considering not only who might be harmed by the act, but also the potential damage. This approach differs from the Donahue against Stevenson's and the Wilberforce standards established in Ends against Merton London Borough Council as a duty of care, and the harm was possible unless there is a good reason to believe otherwise. In contrast, Caparo asserts that no responsibility is due until the three-stage test is passed. It is based on three criteria: possibility, proximity, and whether imposing such an obligation is fair, just, and reasonable. However, Donahue believed that this approach complicates the neighborhood principle. Thank you.
Me, ALIA, ALEZA, and my friend Kavitha will present for case 3, Fasteners v. Marks, Bloom & Co. Okay, for the introduction, Fasteners is one of the investors in BG Fastener, and Marks, Bloom & Co. is the auditor who audited BG Fastener Company. What happened between Fastener and Marks, Bloom & Co.? Fastener acquired the entire shares of BG Fastener. In doing the audit for BG, Marks, Bloom & Co., who is the auditor on that time, did not verify the net realizable values. They just accepted the figures that their client gave. For the facts of the case, took control of a company. One of the primary motivations behind taking over the company was that would be able to acquire the services of two of the company directors. Understood at the time that they assumed control of the business that there were some errors which the accountant had been audited by MBC. Throughout this process, MBC understood that was taking the information into their decision making. The accounts were more inaccurate than had realized, and subsequently claimed for damages. The judge in the initial trial dismissed claim and damage, and appealed. For the liability of the auditor, the court stated that a duty of care will exist where the defendant knew or reasonably should have foreseen that the person might rely on this account for a particular purpose, and in all circumstances, it will be reasonable for reliance to be placed on this account for that particular purpose.
Okay, now I would like to explain regarding the auditor defense. In this case, you can see that the duty of care exists, but the auditor escaped liability on the grounds that the alleged negligence was not the cause of the loss. Next is concept and the principle that involved in this case study. As you can see, that proximity test has been done to measure how far the auditor knew the third party. As you can see, that Fastener is the primary beneficiary of the auditor, that the auditor knew the third party and purpose of the audit, especially for the identified third party. So next is the Fastener is also known as prospective investor for foreseen third party. Next, legal principle, there is no representation since the purchaser wanted to acquire the services of two of the company's directors. Court judgment, the auditor owned a duty care to the investors, as investors only fully relied on the account audited by the auditors. There is no damages rewarded to the Fastener by auditors due to the fact that negligence does not contribute to the company's loss. Thus, the investors can take over the company. In conclusion, we can see that the auditor's cooperation will be more risky, as we can see that the court broadened the auditor's liability.